Among the treaty maxims, the first one is pact as sunt servanda. So, as per Article 13 Draft Declaration on Rights and Duties, so this is the very doctrine originated from the Roman law Jus Gentium, which was governing relations with foreign states. This particular principle exclusively regulate the nature and bindingness of treaties. In gradual course of time, this doctrine became a part of international law. Oppenheim expressed that as per international customary rule, treaties are legally binding. So also Fenwick observed that a state is bound to respect the pledged words, otherwise, the relation of the entire international community would be imperiled and law itself would disappear. The draft declaration of on rights and duties under Article 13 states that every state has the duty to carry out in good faith its obligations arising from the treaties. So the permanent court of justice in some leading cases like treatment of police nationals of Poland and the free zone case, and so also in Greco Bulgarian communities case, consistently held that the provisions of municipal law cannot prevail over those of treaty. Even Robert McNair, who was an eminent international law jurist and a former Secretary General of United Nations organizations, lays down that as it is one of the elementary and universally agreed principle, no government would decline to accept the principle pacta sunt servanda. Article 26 of the Vienna Convention of Laws of Treaty in 1969 states that every treaty in force is binding upon the parties to it and must be performed by them in good faith. So also the United Nations Charter under Article 2 obliges all member states to fulfill in good faith the obligations assumed by them in accordance with present charter. So then the very question arises as to what does it mean by good faith in the strict legal sense. It is difficult to define its exact meaning, so it entirely depends on those parties to a treaty, to its interpretation and performing those provisions in the right manner. The International Court of Justice in its 1997 Hungary, Slovakia case held that the principle of a good faith obliges the parties to apply it in a reasonable way and in such a manner that its purpose can be realized. Also, Article 27 of Vienna Convention on Laws of Treaties 1969 expressly provides that a state could not take the plea of its failure to observe treaty obligations in the name of domestic or municipal laws. As per exception to this principle, whenever a state is found through revolt from an existing state or some territory is ceded or merged with another state, then such newly formed state or ceded or merged is not bound to observe in good faith to such treaty obligations entered by the former state, as treaty is an effective instrument regulating international cooperation among states, so it requires that every contracting party to a treaty to carry out its obligations arising from such treaty in good faith, as it is also considered as another vital source of international law. So, unless it is observed in good faith, then in a gradual course of time a number of states would question its authenticity and applicability or interpretation of intellectual legal concepts and principles. And now we'll go to another important treaty maxim, that is just Cognes. A treaty may be declared void if it conflicts with a preemptory norm of general international law. It is a norm accepted and recognized by the international community of states as a whole, as a norm from which no derogation is permitted and which can be modified only by a subsequent norm of general international law having the same characteristics of general international law. And as per Article 53 and Article 64 of Vienna Convention on Laws of Treaties 1969, which lays down that a treaty is void if at the time of conclusion it conflicts with a preemptory norms of general international norm, so also if a new preemptory norm of general international law emerges, any existing treaty which is in conflict with that norm becomes void and terminates. According to Oppenheim, in just Cognes being accepted as a new norm of general international law, if it is in the common interest of the whole international community, or if it is created for humanitarian purposes, or those introduced by the Charter of the United Nations organizations. So, according to international law export, where those norms having a character of just Cognes can practically be created only by a norm of general customary law or by a general multilateral convention. According to him, three types of just Cognes rules exist in international law. Firstly, those exist in the common interest of the whole international community. Secondly, those created for humanitarian purposes. And thirdly, those introduced by the Charter of the United Nations against the threat or use of force in the international relation. We found an equal similar view between Oppenheim and Beddoes, but the real subject of contention is regarding to formulate on the above basis as to what are just Cognes rule in international law in the absence of a precise definition of the expression like common interest of the whole international community, humanitarian purposes, and the principles of the Charter of the United Nations. Therefore, it is difficult to say as to what these norms are. For some state sovereignty may be just Cognes. For developing countries, unequal treaties may be just Cognes. For some others, economic exploitation may be just Cognes. So, the rule is not well defined so far as to its contents is concerned. However, it does not mean that the just Cognes do not exist at all. It is a general obligation upon every state to cooperate in the suppression and punishment of certain acts such as slave trade, piracy, and genocide. It is the International Court of Justice which would find occasion to determine that what are the just Cognes in international law when a question comes before it concerning as to the validity of a treaty or as to the termination of a treaty on the ground of just Cognes. If and when invoked by a party to a treaty. So, Robert McNair also admits that although just Cognes rule exists in international law, judicial and arbitral sources do not furnish much guidance upon the application of these principles. So, in this class, we discuss two important treaty maxims. One is Pacta Sunt Servanda, and the second one, Jus Cognes. So, in our upcoming video, we will discuss the third important maxim, and that is pacta, tortis nis nocent nis purshant. So this we will discuss in our upcoming video.